Chapter 32, Section 4. The courts began to dismantle segregation. In 1951, getting to school every day was hard for Linda Brown, a 7-year-old in Topeka, Kansas. First, she had to walk a mile, passing through a railroad yard on her way to the bus stop. Then she had to take a long bus ride to school. All of this made no sense to Linda because there was a good school only 7 blocks from her house. But the schools in Topeka were segregated. The school near Linda was for whites only, and Linda was black. Her father, Oliver Brown, decided to do something about that. With the help of the court system, Brown and other civil rights activists began to dismantle segregation. Early court decisions make big strides. In the 1930s and 1940s, the Supreme Court began to strike down Jim Crow laws. In 1935, the court ordered the University of Maryland to admit a black student. Later, it declared white primaries unconstitutional and barred segregation on interstate transport. These were important steps in breaking down segregation. In 1948, the Supreme Court tackled the issue of segregated housing. In Shelley v. Kramer, the court ruled that states could not enforce restrictive covenants. As a result, many city neighborhoods became desegregated. Over the next few years, for example, thousands of black families in Chicago moved into areas that had previously been restricted to whites. In 1950, the court handed down strong rulings against discrimination in education. In 2 cases, the court declared that segregation in graduate schools and law schools was unconstitutional. It began to look as if all separate but equal education was on the way out. A landmark ruling, Brown versus the Board of Education. Meanwhile, in Topeka, Oliver Brown, Linda's father, had contacted the NAACP, which in turn gathered 12 other parents to join in efforts to desegregate the city schools. First, the parents tried to enroll their children in white schools, but all were denied admission. So, in 1951, the NAACP sued the Topeka School District in court. A local court found no willful discrimination. The NAACP appealed the case, and it went all the way to the Supreme Court. Brown versus the Board of Education was actually a set of cases from Kansas, South Carolina, Virginia, Delaware, and Washington, D.C. that had moved up through the court system at the same time. The court decided to combine the cases because the plaintiffs were all looking for the same legal remedy. The Brown case was a class action lawsuit, a lawsuit filed by people on behalf of themselves and a larger group who might benefit. The NAACP's lead attorney, Thurgood Marshall, argued the case. He supplied evidence showing how segregation harms African American children. The most famous piece of evidence was the doll test. In the test, 16 black children had been shown a white doll and a brown doll. 10 of the children chose the white doll as the nice doll. The children were also asked to identify the doll that looked bad. 11 children selected the black doll. According to the psychologist who conducted the test, the Negro child accepts as early as 6, 7, or 8 the negative stereotypes about his own group. The Brown case stayed in the Supreme Court for a year and a half. During this time, a new Chief Justice, Earl Warren, was appointed to the court. Warren was a firm opponent of segregation. Believing that a unanimous decision in the Brown case would carry more weight than a divided one, he worked hard to convince all the judges to rule in the favor of the plaintiffs. Finally, in May 1954, he succeeded. On May 17th, he announced a Supreme Court ruling in Brown versus the Board of Education. We come then to the question presented. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of, deprived of the equal protection of laws guaranteed by the 14th Amendment. Brown versus the Board of Education, 1954. The Brown decision dismantled the legal basis for segregation in schools and other public places. It was one of the most important judicial decisions in the nation's history. It was also one of the many key rulings on civil rights made by the court under Earl Warren, who served as Chief Justice from 1953 to 1969. In fact, the Warren Court became known for its activism on civil rights and free speech. All deliberate speed, much of the South resists change. A year after the Brown decision, the Supreme Court issued a second ruling, known as Brown II. This ruling instructed the states to begin desegregation with all deliberate speed. The phrase was chosen carefully. The justices wanted desegregation to go forward as quickly as possible, but they also recognized that many obstacles stood in the way. They wanted to allow states some flexibility in desegregating their schools in accordance with Brown. In some border states, desegregation took place without incident. But in parts of the South, there was greater resistance. For example, in 1955, a white citizens' council in Mississippi published a handbook called Black Monday, referring to the day the Supreme Court handed down the Brown decision. The handbook called for an end to the NAACP and public schools. It also advocated a separate state for African Americans. Despite such opposition, the Brown decision inspired hopes that African Americans could achieve equal rights in American society. It served as a catalyst for the civil rights movement of the 1950s and 1960s, a time when many individuals and groups dedicated themselves to promoting equality, opportunity, and rights.